So let's move to Louisiana. This case was about, and it really makes you think like maybe there should be some type of thing like called pre-clearance with a Voting Rights Act, where maybe people couldn't mess around with gerrymandering and what. But putting that aside, this is there was back in 2022 an Obama appointee for the district court of the Middle District of Louisiana ruled that there was an illegal racial gerrymander. And so that's where we were in 2022. Black voters in Louisiana make up something like 40% of voters, and there was only 1 out of 6 or 1 out of congressional districts where they were a majority. So they were clearly something was going on there that diminished Black people's voting power.
So right. And so the Supreme Court famously then issued that decision last term that sort of revived the Voting Rights Act and said, actually, racial gerrymandering is still bad. And so the district court judge there was vindicated, and the Louisiana legislature was ordered to redraw its map. So the Louisiana legislature draws a map with a second district that has a near majority of Black people. So now you have a map that looks, significantly more like the racial breakdown of the state. You've got 2 districts that are likely to elect Black representatives. So what happens then? Well, a group of conservatives then go to court and say this new map, which is ostensibly fairer and compliant with the Voting Rights Act, is actually unconstitutional under the Equal Protection Clause because the new district is just too Black. There are too many Black people receiving too much representation in this new district, so we think it has to be struck down. They are lucky enough to draw a court, and we don't have to get into the details, but it's actually a 3-judge court that 2 of the judges are Trump appointees. And the 2 Trump appointees are essentially trolling the Supreme Court here. They step in and they strike down the map. And they say, you know what? This is just too much power for Black voters. We can't accept this. This is a race-based redistricting decision. And so even though we're less than a year out from the Supreme Court saying that these kind of districts are actually required by federal law, we're going to say that this one is unconstitutional. And everybody scrambles up to the Supreme Court to get an answer because, of course, elections in Louisiana are not that far away, and they sort of need to know what maps they're going to be using.
Now, my understanding is that part of the argument, and there was an Alabama case, right, that had basically supposedly made this moot on some level, that the Supreme Court had issued on. But my understanding is that the plaintiffs here were arguing that the districts were not compact enough. That one of the elements of redistricting is sort of just like a general principle is that you want the districts to be as compact as possible, as opposed to, I guess there's one in Louisiana that sort of like is a thin one that runs almost like the entire length of the state in the middle, almost like it was like a spine in some way. And that was the basis of their argument. And that in shooting that down, the Supreme Court is opening the door for other types of like sort of gerrymander hijinks.
So compactness is something that the Supreme Court has called a traditional factor of redistricting, but it's not an iron law because another factor that's key is something called communities of interest. So let's say that here's a sort of micro example. There's a big Caribbean community outside of DC in one particular part of Maryland, right? The way that they have organized their lives and businesses and whatever is not into a compact district, but they're placed in the same state senatorial district that looks a little funky because they're deemed a community of interest, and the state felt that they should elect a representative who could represent their interests, or a state senator. So that is sort of the other feature that's in tension with the compactness issue. And in this case, a big fight was, well, can you sort of collect Black communities in a district and say they're communities of interest and put them in a district that looks a little bit funky? Or is the district so weird looking and so contrived that it's obviously unconstitutional? And I think this district was very different from the one in Alabama that the Supreme Court struck down. Okay, the district in Alabama that was struck down, it was like this snake that went around and sucked up every Black community that it could, and was designed to prevent Black people from living anywhere else, so that it could just be this one deeply Black district and everybody else could be in their own lily white district. The Louisiana district was different. It did have a majority Black population. It did look a little bit funky. I think that the state legislature, and I don't really want to give it to them because these were sort of cynical Republicans, but I think they were trying to follow, for the most part, the court's order, the original court's order, which was that your districts are not giving Black people representation in the congressional delegation. You have to draw another one that will boost their representation. And so these are the two poles against which all redistricting law has to go through. And it's sometimes difficult to see if one is veering too far one way or the other. Does that make sense?
And they were also trying to, I think, protect the incumbents a little bit too. So
that's right, of course. And they basically decided, they said, Louisiana's Republicans said, well, we have to get rid of one Republican incumbent. We'll pick the one we like the least and screw them over with this district. And that's what they did. But the Supreme Court has also said that that's okay. So when this was appealed up to the Supreme Court, I actually wasn't surprised to see that the 6 conservatives stepped in to restore the original map, even though it had more Black representation. In part because they have been really big on this idea that courts shouldn't change election law shortly before an election, which includes primary elections. And so I think what was going on here was, this case is not over by any means, but they stepped in, I think, because they want to make it clear that if an election is even like 8 months away, the federal courts should not be messing with maps. They should not be messing with voting rules.
Okay. And is there any there's no poisony pill type of thing that's going to come back down the road as a way to further disenfranchise people? The
whole thing is poison pills. It's a giant poison pill. Either the Supreme Court now uses that principle to block progressive decisions, say that a judge says that some absentee voting restrictions are unconstitutional. The Supreme Court's going to use the same rule to block that decision and say it's too close to an election. You can't make it easier for people to vote. And then this whole case is just a mess because, like I was saying, you've got this legitimate interest in boosting Black representation in Congress and boosting, the proportional representation of Black voters. But at the same time, you've got this concern about districts that are sort of contrived to ensure that only Black people live in them. And you've got to navigate between those two things. Republicans are really, really good at sort of scheming to make every district that's too Black look like it's unconstitutional and make districts that are too white look like they're just fine.
If I'm in a Republican dominated state, I'm just going to wait until we're 8 months out from an election to say no more mail-in ballots. No more, we're closing half of the polling stations. Exactly. And then I know I'm protected, and I can do that every year.
Yep.
I can do that every cycle.
Back in the day, before Shelby County, you couldn't. You had to run everything by the Justice Department. But now pre-clearance is over, so you can do whatever you want. And yes, the legislature can change the rules just before an election, but the judiciary can't step in to block them, even if they're patently unconstitutional.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.